The remand of female passenger Comfort Emmanson in Kirikiri Correctional Center for allegedly assaulting an Ibom Air cabin crew member and some security officers during Uyo-Lagos flight on Sunday has triggered public outrage and accusations of selective justice. Viral videos captured Emmanson slapping and kicking airline and airport officials, including a female air hostess, after she allegedly refused repeated instructions to switch off her phone before takeoff. She was seen being dragged off the aircraft by airline operatives in a way that was dehumanizing and showed off her private area.
The Nigerian Bar Association didn't mince words in its reaction as the NBA, in a statement signed by its president, Afam Osigwe, and Secretary General Dr. Mobolaji Ojibara, condemned the treatment as degrading and unlawful. They demanded an independent investigation, the immediate withdrawal of the lifetime ban, and prosecution of those who filmed and distributed the footage exposing Miss Emmanson's nudity. The NBA also offered to provide pro bono legal service to Miss Emmanson to ensure her rights are protected and that she obtains redress for the violations suffered. Well, joining us this morning on Breakfast Central is President of the Nigerian Bar Association, Afam Osigwe. Good morning, and thank you so much for being here.
Good morning, and thank you for inviting me.
Good. I would say that it's rather a good time to have you be here with us because we want you to speak directly to the press release that did come from the NBA, and especially what legal grounds does the NBA believe Ibom Air violated in its treatment of Miss Emmanson. So I'm sure we're going to have a fully packed conversation that we can start right away. So first of all, let's start with the press release. And what is the NBA stance on what did happen to Miss Emmanson and, of course, Ibom Air?
Now, in a summary, our press statement sought to address two major issues: the treatment of a person who is alleged to have committed an offense. Now, Section 34 of the 1999 Constitution guarantees to a person the right to dignity of the woman person. And the treatment meted out to the lady, as contained in the video footage which has since gone viral, indicates that that right was not respected by the airline. It's possible she may have committed the offense, but the Constitution guarantees her a presumption of innocence. So until there is an adverse finding by a court confirming that she committed that offense, and even after that, she continues to enjoy her rights of dignity of human person, and nobody ought to be treated in the manner she was treated, being dragged on the floor, even kicked by those who came to bundle her out of the aircraft. And indeed, there are better and more decent ways of effecting her removal from the airplane. And video evidence would also suggest that she also volunteered to willingly leave that aircraft, and they refused. So about how people are treated. And secondly, the rush to judgment and condemnation and ban by Ibom Air and the airline operators of Nigeria, that is whimsical, that is arbitrary, that is condemnable and should not be permitted. Without hearing from every party's concerned, apparently the AON heard from Ibom Air and believed Ibom Air and rushed to ban a person for life. While these may be private businesses, the license that permits them to operate is public property. And to that extent, they have a duty to the public, a duty to their passengers, not to abuse people who patronize them, who are their passengers, and who would be beneficiaries of the services that the government has licensed them to provide. So the fact that they are private businesses is not enough. To the extent they have a public trust to operate those businesses and cannot act in a manner that detracts from the personal and private rights of individuals and violate the Constitution and act in such a brazen manner. And also, it's very, very worrisome that an airline or any person will record video that shows a lady being stripped naked, shows her nudity, and feel justified to air such a video without redacting that part of it or in some way digitally blurring it so as to respect her privacy. Nothing can be more or less dignifying than the conduct of releasing that video. And if the airline claims not to have done it, we need to find out who did it, because it calls to question our respect for our laws, it calls to question our respect for the dignity of the human person and our decency and how to treat passengers who patronize whatever business. We can't have a devil-may-care attitude in thinking that it is right to treat people the way we want and then ban them without giving them a hearing. That is not the Nigeria we know. That is not the Nigeria that our constitution regulates and stipulates how things should be done.
Absolutely. Definitely goes against the principle of natural justice. She cannot be condemned unheard. I have another question, but I want to push back on something that you made reference to, or just for us to dig deeper a bit. You referenced the fact that they made a video, posted her nudity without even cutting that part out. Now, beyond the airline has to explain how that video got out, that's one. But I'd like you to also speak to the fact that it's being circulated on social media by blogs and by individuals. I mean, is there a crime there? And I want you to speak to that and why maybe it's important that those videos are not reshared in the manner that they are circulating on the internet.
Now, sharing videos or such recordings, which may in some sense amount to pornography, or that violates person's privacy, may in appropriate case amount to a crime under the Cybercrime Act. And that would be for the relevant agencies to look into it, find out who did that video and who circulated it. For me, that it would show to what extent a person or a business would go to justify their action also speaks volumes about how far we think we can go in order to prove that the other person is wrong and we are right.
All right.
And I think, yeah, go ahead, please.
No, please just land on that thought before I ask the next question.
And I think that we should be much more worried about whatever alleged offense she is deemed to have committed. And look into this aspect of it. In any society that does not respect its citizens, that does not respect the dignity of the human person, will ultimately engender a situation where might becomes right. And people can do anything as long as they think they have superior power, they have the contact and the power to do as they please. And this would appear to be one of such circumstances.
All right. Thank you very much for exploring what the implications of that are. Let's now head to Kirikiri, where Comfort Emmanson has been kept. I don't know if you've, I'm sure you've had the opportunity to look at the charge sheet. We're seeing that her hearing has been delayed till October. Is that fair? Is that just? And also, we don't know if there's been any moves to get her bail.
It is in a society, the bail process has been abused by both the courts and the prosecution. If you look at the offenses with which she's charged, they're ordinarily bailable. And it is shocking that a prosecution and a court which rushed to commence trial and which ordered the remand of a person will feel happy in their mind, and today is the 13th of July, to order the remand of a person who is not accused of treason or murder, and think that it is justified to adjourn such a hearing to October. And it gives the impression that the whole essence of the rushed trial is just to punish her, even if she may ultimately be found innocent. And the magistrate who made this order should look at this process and know that he or she may not have been fair, may not have acted in accordance with the law. There's nothing in this matter that justifies such a long adjournment. The court should have made room that there may be application for bail, considering that the alleged incident occurred the same day the lady was charged to court, and there may not have been adequate time for a bail application to be brought, assuming the magistrate may have insisted on a written bail application. And it is most unfair that we should have this kind of system. It is most unfair. And when you also consider that other person who is alleged to have committed a similar offense, and even a worse one that really threatened the safety of the aircraft and its passengers, is yet to be charged to court, it brings to the fore the kind of society we run and the kind of impression we give out there that justice depends on who you are and your standing and who you know in the society. And that's not the kind of impression we want to see police and other prosecutorial agencies give to the whole world.
All right, so let's get this very clear. What is the NBA planning to do now? We've looked at different scenarios, almost similar in terms of action, both involving an airline, though different, one Ibom Air, the other one Value Jet. And we've seen the justice system apportioning or giving justice to one, in fairness, like some have said. The other one, they said it looks it's questionable. Well, my question to you would be, what is the NBA planning to do in these two situations? Or are you just focused on the Emmanson case? Are you also going to, is the NBA also going to look at the case involving Kwam 1?
Now, we can't compel the police to investigate, but we are an advocacy group, a body of professional colleagues, associates, colleagues. So what we will do is to review them and also make our findings and our position known about these two cases and the fact that they give the unnecessary or perception that we have selective justice in Nigeria and that our administration of criminal justice system and our bail system can be better than it is at the moment, and that the way we apply the judicial power to deny bail or to grant bail is being abused or is being implemented in such a way that does not engender public confidence in it. And in our press release, we talked about providing her with pro bono services. Now, you have to know that this is dependent on her inability to retain counsel. And if I'm to believe media reports I've read, she has engaged the services of lawyers to defend her, but the NBA will continue to hold a watching brief and also investigate through our Lagos branches and the Ikeja branches and other branches in Lagos State the aspects of it that call for public interest and attention, so that we bring to the fore what is happening. And also our section of public interest and development law Speedle will also activate their litigation team to work in this matter and look at aspects of it that may not make us look good, because indeed there are aspects of them that are worrisome and raise concern. And we're also ready to work with our defense team to provide her the kind of defense she may need if they permit her, because she has the right to retain counsel of her choice and we can't impose ourselves on it. But as an association, we'll look into the administration of criminal justice elements of this matter and also make our position known as time goes on.
I mean, you've talked about the flaw in our bail application system. I wanted to confirm if we have any updates regarding the possibility of Comfort getting bail. Have there been any applications made on her behalf, or is she expected to remain in Kirikiri until the 6th, or is it the 11th of October?
Her lawyer I believe would have an instruction to file a bail application, and I believe they will do that. And I believe the magistrate should know and also give an earlier date for the hearing of such a bail application. There's no need for that long adjournment. The court could have adjourned for a few days to enable her to make a written application for bail if indeed it was considered very important to deny her bail and to remand her in prison custody.
All right, going back to the Kwamwon case where, that was used as a comparison with this Comfort's case. Part of the criticism that we heard was those who had said that what he had done amounted to terrorism, and they wondered why he was not also brought before a court of competent jurisdiction. But there are those who have said that he apologized. I mean, to err is human, to forgive is divine, according to some very influential people who have reposted his videos and have said, just forgive and forget. Yes, he has apologized. But what is the place of forgiveness when an offense has been committed?
Now, the state must not in every circumstance prosecute. But whereas in this case, these two incidents occurred in the last 1 week, and one would appear to be graver than the other, and we rush to prosecute one and stay silent about the other, it gives the impression of selective justice. We can't compel the police to investigate, and I will not be here to comment on whether the action amounts to terrorism or not. That would be a call for the police or the Attorney General to make. But as it were, and one being rushed to court and remanded while one, and nothing is yet to be said about prosecution, gives the perception, the impression that our justice system is not even-handed. Whether the person apologized or not is a different thing. When people also plead guilty in a criminal matter, there's also some way of admitting and maybe apologizing in allocutus, what we call allocutus, which is done before the court sentences. It's not about the apology, it's about the fact that one was quickly rushed to court and remanded, where one would appear not to have been, no step has been taken to prosecute the other person. And this is what we are talking about. The perception, the appearance, with the right-thinking person looking at these two circumstances, believe the power of the police to prosecute has been fairly applied in these two circumstances. And the conclusion will be a resounding no. A resounding no.
Okay. The document you have on the
perception.
Yeah, the document you have on the screen there, I don't know if you can see it. Yes, exactly here. we see this document and we seem to have questions about it. I mean, since you are a lawyer as well, that document is dated the 11th of October. Many have asked that, look at the date, look at the timing. Isn't it too long a time? And why must she be kept in prison, especially Kirikiri, for that long? Is it what the law would indeed accept, or would it be part of what the law indeed supports? We just want to clear the doubts of many who have asked this question, especially online. Is it right to keep her in prison up until this time? I'm afraid we can't hear you. I don't know if you're muted.
The audio, we're having a bit of challenge with the audio.
Okay,
yes,
go
it's
ahead,
back
please.
now. Please go ahead. It's back now.
So what I was saying that earlier on when I spoke about the worrying length of adjournment granted by the court in this matter.
Yeah.
That there was if the court rushed to judgment to remand, the court shouldn't have given a very long adjournment. Should have given a shorter date to see. But this is not without remedy. As if the court can also fix the bail application for hearing at a shorter timeline. But the facts and circumstances of this case and the long adjournment, when read together, don't give a good impression of the court or our criminal justice system. And we must really have to look at our bail process, use of bonds. If we insist on oral application for bail or written application for bail, if that, I don't know the facts of this case, how the court arrived at it, but I think the court shouldn't have adjourned for so long, having reminded the person in prison custody. I have counsel go through the rigors of getting a shorter date for the hearing of the bail application. This court could as well have adjourned to 1 week or at most 2 weeks to give room for a bail application to be brought to consider whether this person should be released on bail or not.
I just want to
don't give a good impression. That's the point we're making.
Okay, I want to follow up on that question as well. We're told that she's been banned for life. Does the NCAA and, of course, the flight have the powers to do that to an individual, a Nigerian citizen?
My view of the top is that as airline operators of Nigeria does not have such powers. That will be for the regulatory body, the NCAA, to do so. And also the manner they rush to do the same, without even conducting an inquiry, without hearing from the lady, without, as it were, being seized of the full facts of the case, shows an arbitrary and whimsical act that violates her right as enshrined under Section 36 of the Constitution to be given a fair hearing. That is assuming that body has a power to give it. And all this portends is danger for the air traveler, who may be wrongly accused by the crew, an airline crew, and before you know what's happening, the person has been banned for life. No airline, no association should be allowed to wield such power, even if their members are the ones who own these airlines. I made that point earlier, that while these may be private businesses, they are regulated and operate under licenses granted by the law. And the exercise of the carrying on of their business must be in line with the dictates of the law. They cannot act and behave as if they are above the law or no law applies to them. So the live ban, the purported live ban, must be lifted and puts a shame on them, because they ought not to have acted in such a manner without a hearing. As we say, even in the Garden of Eden, God gave Adam and Eve a fair hearing before punishing them. If God could listen to us, even when God is all-knowing, how much more human beings, when they accuse others of having committed an offense? Why rush to judgment? If you think you're right, why not hear her? And also have the opportunity of getting the full facts of the matter before acting. That was very hasty, that was unnecessary, and violated her right to fair hearing. And that's not the kind of standard we want to hold up to the law and to the world or to our larger society.
Absolutely. I mean, even here in Nigeria, laws provide that regardless of whatever crime you've been accused of, even if it's as grave as murder, you're entitled to representation in court, you're entitled to hearing your own fair day in court. So now, how do we guarantee that Comfort has fair hearing? I know that the NBA has been advocating for her. I had asked about the bail application, and I mean, you had made reference to her lawyer, but I know that the NBA is offering free representation for her. Will there be maybe an application or a conversation that the NBA will have with her lawyer? Will there be a fresh bail application made? How soon? Do you have an idea how soon that will be made and what the next steps are? Because the longer she stays, we all know about the terrible conditions in Kirikiri prison. We've interviewed guests on the show who have had experiences, and it's the most dehumanizing experience that anyone should have. So the longer she stays, the worse it is for her. How soon are we getting on, beyond the conversations to actual actions to ensure that Comfort has her day in court and is out of Kirikiri prison?
Well, I intend to speak with our lawyer this morning. A name has been publicized as the name of our lawyer, and incidentally, it's a person well known to me. And I know he's a very diligent lawyer who would have taken immediate steps to file application for her release. And I also believe that the court will be persuaded to hear that application for bail immediately. Nobody needs to go through what she's going through, and nobody needs to be condemned and dehumanized the way she's been dehumanized. And our court system should know that it is under watch. The whole world is watching to see what it does. And the courts need to act in a manner that gives public confidence and makes the whole world see that what you get from our court is not dependent on your status or whether you are rich or poor, but on a sense of fairness and an even-handed justice as stipulated by law and the Constitution. And so the NBA will continue to play a supporting role because she has retained counsel of her choice. We cannot impose ourselves on her. But this is a systemic thing. We have to work and observe the system and also ensure that the right things are done and that justice is served in this matter.
All right. Thank you very much for joining us this morning, Mazi Afam Osigwe. We'll continue to follow up with the case. We look forward to having maybe a follow-up conversation when you've spoken with the lawyer, and the matter has been taken over by the NBA, and we look forward to seeing the progress in this matter. Thank you for your time with us this morning.
Thank you for joining us. Thank you.